Two matters. I'd ask you to look at the confirmation of the minutes for last week, Tuesday. It was a 2-page minute. Can somebody move for its adoption? You so move, Mr. One correction.
Yes.
Right. Make that corrected for me. Very well. Thank you. Thank you, member. All right. So, and you will second it, member Scott Montley. All right. Any matters arising apart from the minutes? I think in that discussion we had a deliberation as to, that was our first meeting, what would be the quorum, and I think we signed off, Mr.
It was deferred. So we're going
We had deferred it.
total or 5?
We had deferred it to say whether the quorum would be 4 or 5.
Here's her mic, please. Her mic, Chairman.
Minister, I thought then that it should be 5
Okay.
because of the size of the committee, but
Sure.
after today, I'm going to say 4.
All right, so we are going to say that the quorum will be 4, including the chairman. Yes,
I know there's a minimum number of 3. Is there any reason we're not sticking with that minimum, given your very aggressive timelines?
we can, sorry.
I know.
Size of the committee.
Well, it can be 4, including the chairman. I'm very likely to be here for all the meetings, and 3 other members. Okay?
I can live with that, Chair.
All right, thank you, Minister Nixon. There was one other matter for where I think we had planned, and I just want to confirm if we can agree on next week, Tuesday at 2 o'clock.
You want to go with Tuesday?
Is that convenient, next Tuesday?
No, Minister is saying no. Chairman, given the current sitting and the persons who normally show up, I don't know if you want to find a different date for the meeting.
Why?
Because remember, we're looking at quorum and availability of the members after attend.
Well, the truth of the matter is that we were hoping to take the Ministry of Education, but if Minister Dixon won't be here, it might not be appropriate. The problem is that if we don't set some dates, this thing could drag on.
No, man, we can set dates, Chairman.
What dates you have?
So, if you want to find some additional dates, I'll look for additional dates outside of the Tuesday. Granted, we have budget debate in March. I'll provide you with the additional dates later on.
All right.
Or now we can-
So we're not going to go with next Tuesday? How do other members feel? Because we could invite, there are at least 2 other team. We have the officers, did they get in touch with you? The children's advocate?
No.
And also, well, we did get something from,
Any submission from them?
no, but we did get from Hear the Children Cry. We got that one. Yeah. So we could invite them for next Tuesday, and if the children's advocate can make it next Tuesday, we'll invite both of them.
So you're confirming next week?
So we're confirming next week, Tuesday. We hope, would that be convenient for you, Member Buchanan? At 2 o'clock, so we go next week, Tuesday at 2 o'clock. All right, team? So next week, Tuesday at 2 o'clock. Please remind Mr. Nash that we will invite Hear the Children Cry and also the Office of the Children Advocate. I had spoken to Member Diane Gordon Harrison, and she is prepared to come before the committee. Whether she'll be ready for Tuesday, I will check out today or tomorrow. But
The date has been set.
have you had any other correspondence of any other team that wants? CPS, I would like you to be here when Ministry of Education and CPSA, are here when they come. Huh? The following Tuesday, no, that's when we open the budget debate. That's at 2 o'clock. But we could have it in the morning. how do members feel that we have a meeting on the 10th in the morning? Member Scott Motley?
That's taken, Chairman.
Huh?
That's taken.
No, no, apparently it's taken. That time is taken. That time is taken. What about the Wednesday then, the 11th? Remember that's taken too? All day? Huh? I know, that's why we have to slip into every time we can get. So,
I've seen them from 10 to 1 on the 11th.
no, but what about 2 o'clock on the 11th?
Seems to be open right now.
So let's try, we will confirm next week Tuesday, next week Tuesday we'll confirm whether the 11th at 2 o'clock is possible, okay? So for the moment, it's the 3rd and the 11th, all right? Because we want to take as many presentations as possible.
So you're confirming for the 11th then?
No, we'll confirm
On Tuesday?
on Tuesday next week. So we're conditional, the 11th, depending on members, okay?
Yep.
All right, having go through that matters, no, the main matter this morning is presentations from Jamaicans for Justice. And Ms. Mikkel Jackson, I know you'll be leading the team, so you will indicate to me the members of the team and who will be dealing with it. Now, we intimated to members that you would be coming and asked them to read your report, which you had presented some time ago. I must tell you, I told the members that I read the report. I can't tell you I remember everything, so I'm going to rely on you to identify. I don't want you to read the report, obviously. So what we're going to ask you to do first is to give us a summary or give us an outline of your report.
Yes.
And then immediately after that, you identify the main issues that you'd like the committee to deal with. So you do a broad overview, but bear in mind, members may stop you at any time, okay?
Yes, Minister.
So
Thank you.
it's up to you now, introduce your team and you can proceed.
Good morning to the Honorable House. We're certainly happy to be here, and we are grateful for the opportunity to make our presentation. My name is Mikkel Jackson, the Executive Director. So I will lead on just 2 minutes of the main findings in the report and turn over to my colleague, who will lead on some of the recommendations, and I will interject accordingly. But I will allow them to introduce themselves, please.
Good morning to the committee. My name is Jade Williams. I'm the Policy Research and Advocacy Specialist at Jamaicans for Justice.
And are you saying you wrote the report, or are you drafted it?
Team effort, Minister.
Yeah.
Good morning to the committee. My name is Abigail Letman, and I'm the Attorney at Law / Legal Officer at Jamaicans for Justice.
Okay, all right, wonderful.
All right. So in the spirit of just moving quickly, one of the things I wanted to start out with is that we shared some additional documentation to the committee.
Did
My
members
apologies
see-
for
sorry
sending
about-
it.
Did members see the additional document? Okay. Go ahead, sorry.
So those documents highlight a few things. One is a policy brief that we drafted that provides greater detail and a recommendation that we are certainly pushing, and we hope that the Honorable House will be so guided in considering the recommendations kindly, which is on the decriminalization of consensual sex among minors. And I know that the committee had a lengthy discussion at its last sitting. And we also found it fitting to share information that we gathered from the Department of Correctional Services around the number of children in the detention facilities, juveniles aged 12 to 17, also information from the Jamaica Constabulary Force within the period, I think, 2020 to 2024, so that the committee can get a greater appreciation of the types of offenses for which children are institutionalized, as well as the offenses for which children have been charged by the police officers. So we found it fitting to put those information before the committee to aid in its deliberation. So again, my apologies, we just printed them last evening, but soft copies will be shared with the clerk.
They were shared with members.
Okay, great. Now, to move on, just in summary of the report, and then I turn over to Ms. Williams. The report was done, or the information gathered, thanks again to the Ministry of Justice and Constitutional Affairs and the other agencies that responded. We submitted some Access to Information Act asking for information from the ministry, the Court Administration Division, the Jamaica Constabulary Force, to get an understanding of the number of children that were recommended for diversion. And the report captures information between the period March 2020 and January 2024. So in reading the report, I ask you to consider the time frame, because you would recognize that the number of children who were diverted, they're certainly less than the data that the Ministry of Justice presented at the last sitting. So we ask for that consideration to be made. But some of the main things I believe is important for us to be guided by when we look at the findings in the report, and Ms. Williams, you can help me here in terms of the pages that the committee can find the information, would include the offenses based on what the courts refer the children to diversion versus what the police at the time referred the children to diversion program. And what you found at that time, based on the data received, was that there was certainly a disparity between the number of referrals by the courts versus the referrals by the police. For example, there were 218 referrals by the police at that time, and it came from Sissoko. So you found that those referrals by the police at that time, they were largely sexual offenses matters. When you look at the number of referrals by the courts during those periods, it was 1,234. And forgive me, I'm speaking from memory because the page and my thoughts not connecting well. So you would see that there's disparity again between the referrals by the courts and the referrals by the police. And it's something for us to look at specifically now when you start focusing on the offenses for which children were referred. So when you look at the offenses by the courts and the completed cases now, not the referrals, the number of cases that were completed based on the data from the courts, 62% of those cases were sexual offense matters. And then we start to look a little bit deeper on the sexual offenses matters. Reason being, and Mr. Buchanan and others who are attorneys here can, perhaps look at it with this lens as well. Normally, when you have like a burglary charge, if it is that it was forced, you would see an accompanied charge attached to it, for example, grievous sexual assault and so on. But when you look at the offenses that the courts diverted these children, they were standalone charges, if you will. So it suggested possibly that these were consensual acts. We can't speak definitively, but it's just what it suggests based on the charges and how they were documented in the data gleaned from the courts. So a number of them, again, sexual intercourse with a person under 16, indecent assault, 62% of the completed cases. And I made mention that the cases that the JCF referred, 218, all came from Sissoko. And we sought clarity from the JCF. Are you sure that you did not make any referrals at that time? And we were told, no, it's just from Sissoko. And we note again, there have been increased referrals based on the presentation at the last meeting, but it is something for us to consider. Ms. Williams, as our policy specialist, she does trainings to law enforcement officers. And between the last 3 years, we would have trained perhaps about 300 or more police officers. And I can tell you, when doing those trainings, if we have a total of 10 officers who are familiar with the child diversion program or made diversion, we would be generous in that number. So it means that we need to do the public education in law enforcement and also with the defense counsels, because the awareness among attorneys, based on what we know, it is low, and it is something that we really do need to push. It's very high among prosecutors, which is why we're making recommendation for expanding the referral program. So that is just a synopsis of it. Oh, lastly, you would see us raising some concerns about other offenses, children in need of care and protection. And I hope we have a conversation about that, because it is not a criminal offense. And I fear that when those things come up in the justice space, it's almost that it becomes a status offense, as we know that language for children. And it's less about the parents doing what they ought to and more about children being diverted for actions where they need care and protection. But again, it's the how it is documented and flagging a concern. The other area, very lastly, that was mentioned in the last committee meeting is uncontrollable children, and we have concerns there. It's something we've been advocating needs to, really put a halt to. And you see uncontrollable children, especially in the rural parishes, coming up a lot when you look at the data coming from the courts. And I think we have to have some conversation about that as the conversation continues and the recommendations are heard. I will turn over to Ms. Williams.
Right. Let me thank you for your brief introduction, Ms. Jackson. And you once again identify a thing that the committee itself identified, the lack of information, especially amongst the stakeholders who should know about it. And I must tell you, a lot of the information that I gather in terms of how judges interpret the act was because we had a meeting with them, actually organized by the children's advocate. And it is then and there, sitting there and listening to the judges, how they misinterpreted and felt, that the act should be done this way. And that is why the committee members are being asked to look at it so we make it very plain in the act. Because, yes, the act could be misinterpreted in its present form. But your point, though, and, Ms. Clark, and they will tell you, I am at pains every month to say we need to speak more about the successes of the child and other justice services to the various stakeholders. So although we have had meetings with the High Command of the JCF, it looked like we need to go into each of the parish and speak to all of the various superintendents and the officers in charge. So, in other words, and it is something which I too have discovered. If we literally had to explain to the judges, because many of them did not know about the child diversion. This is a couple of years ago. And when you talk to the officers in the parishes, they ask, what is that, sir? When you ask about child diversion. So I think, Ms. Clark, you can see what Jamaicans of Justice has also identified in contacting Sissoko. Yes. And many of those children should have been referred.
Yes, and just to say, Minister, an email correspondence was shared with Dr. Kevin Blake, and he's quite amenable to the recommendations, and he offered some of his members of his leadership team, and we had a meeting with the officers. And one of the misconception, if you will, is that the matters for which they have the powers to divert is sexual offenses. And that is something, the first schedule, we really do need to do the public education. And we have been assisting in our limited resources, but the ministry, over to you. In doing
I am aware, and a lot of people, I'm aware, and in fact, if I might say this, colleagues, I go around the country. I have justice fairs almost every month. Sorry.
The offenses for which they have the power to divert.
No, wait a while. I'm trying to turn off your. No, too many mics are on. Turn off your mic, Ms. Williams. All right, go ahead now, Mr. Jackson.
The offenses for which the police is empowered to make referrals for diversion, there is seemingly a misconception that it's sexual offense matters, like sexual intercourse with a person under 16, and they can't refer for anything else, which I think perhaps that misconception was mostly in the earlier stages, which may have led to Sissoka being primarily the referring agency. But one of the things we do caution in our report is that the police is utilizing their powers of informal caution, which is not necessarily documented based on what the wording of the legislation says, because the legislation does make allowance for the formal warnings to be documented, not the informal. So there may be more informal cautions being done, but it's not documented. And that still may be a challenge, because if it's informal, it means that the child may not be referred to the diversion program if that child is in need of it. But Ms. Williams, I don't want to preempt her, so when the committee is ready, I would defer to her to
Hold a
speak
second,
more.
Ms. Williams. You go ahead.
Minister, somebody said over to the minister, and I want to join them, because it is true. Although you do go into the parishes and you have fairs, let us face it, when you have a fair, half of the parish, the people in there are not exposed to it. And I do want to heavily say to you, over to you, you do need a PR company, to let Jamaicans know. I don't know if you recall when we started, 2 is better than too many, and now you are, and it was all over until we have all heard it, and now you're encouraging people to have
2 now.
2 now, exactly. And I want to say that where we talk about crime and the levels of crime, it is at this stage that we can control crime if we grab our young people at this stage. So we are desperately waiting for you to get the funds for a PR company.
You are aware, when members Golden and Scott Motley from the last meeting complained about the lack of information, we met here just afterward and say, we clearly need a PR company to let Jamaicans know about the intricacies, all the details of the child diversion. So, and I must tell you, members, since then, I've had a discussion with my permanent secretary that we must push and elaborate all the different matters that relate to child diversion and other justice services, but in particular, child diversion, so that more the stakeholders, the police officers, the judges, know more about how to refer matters to the child diversion officers. And I guess the same will go to the schools, because when I go to the schools, nobody knows about child diversion. So it is a challenge for the ministry. Okay, thanks. So sorry, go ahead.
I just need some clarity on 2 things. You said that the law enforcement was under the misconception that Section 10 is the only thing they could refer?
Well, generally sexual offenses. Yes, that was the misconception.
All right.
Not including rape, though.
Not including rape.
Right.
All right. So this may be an opportunity in terms of when we reassess what the schedule looks like, because currently it's only 3 offenses under the sexual offenses, and they're based on the charts that you gave us. There's a little bit more, like grievous sexual assault, which is usually attached sometimes to some of the offenses. It kind of prevents us to bring the confusion. So if the term ignorance is no excuse to the law, hearing what you said, I'm wondering if ignorance to enforce the law or misapply the law applies to the officers at this point. But before Ms. Williams embarks on her presentation, I'm kind of wondering, though, you made mention about boys being more being charged with the offense of sex with a person under the age of 16, but the law in my mind, and the chairman can give guidance on this, the language is clear that both male and female can be charged. And so that's a misapplication. And no, I'm hearing the culture, because I do understand that sexual intercourse is defined a certain way under the Act, which kind of says it's the male who initiates. But Section 10 was carefully drafted, and my friend will complain later about the history. If we look in the answer, the object and purpose of Section 10 and whether it had ever intended to capture close in time. Yes. So I just want to caution or suggest that we really look at it, because there's also the aspect of whether or not we need to regulate in the absence of what we are going to start to coin uncontrollable parents rather than minors.
Mm-hmm. Well, I hope as a parent that framing is not ever put in law. Right? But we do take your point, which is why we invite the committee to read a detailed recommendation that we have placed for your attention on the decriminalization of consensual sex among minors, which will expound on Section 10, perhaps creating a new section altogether to capture sexual offenses, sexual activity, my apologies, because there is a case that Ms. Williams represented as an attorney, and the Jamaica Gleaner carried it. Young man, 15 years old at the time, on a roll, brilliant young man. He did what you call digital penetration with his girlfriend. Because of the framing of grievous sexual assault, it was captured there, and the police is not empowered to divert grievous sexual assault. Because of the framing of the legislation, there is some difference of opinion around Section 10 and how sexual intercourse is actually defined, and whether or not it actually applies to females. But nevertheless, the young lady was not charged, just the young boy, and Ms. Williams will indicate as she progresses many court dates, missing school, and so on. And though we recommended diversion, it actually never happened because I think the social inquiry report, it was not before the courts. Please expound, Ms. Williams.
One second. Yes. It was really a matter that once the child was before the court, recommended to diversion, there's a process that the court should send their court file to the child diversion committee, to the offices, so that they can do the assessments and then do the intervention. And we would have had 2 or 3 court dates where the court file had not yet reached the child diversion office. And then when it reached the child diversion office, it was on the court date. And so they wouldn't have been able to have done the intervention. On the last court date, we would have had the office just receiving the information for the child, to be able to schedule the assessment, which is only a part of the process, because once you're assessed, then there will actually be the program that you will embark upon. And this would be an offense that he would have been brought before the court for a year ago. So, looking at that length of time, even the court was considering how difficult this would be. He's doing his CXCs to be continuing to come to get updates on the program. So actually the court took jurisdiction of the matter and heard it in the children's court and had him plea so that we could end the matter at the next court date rather than continuing on the diversion path.
Good. That's okay. All right, so we'll leave it up to you now, Ms. Williams. Mm.
All right, thank you. So one of the first recommendations that we wanted to share was speaking to a tiered diversion framework, and this is similar to the framework that is in the South Africa Child Justice Act. What that framework would do is allow for there to be a greater marrying between the offense, the specifics of the child, and the type of intervention that happens. We also think it would assist the court in knowing the level of matters in which the court is able to provide diversion. We do think that there is a lack of well, yes, a hesitation from the court to use the diversion legislation as broadly as the diversion legislation allows them to use it. And having seen South Africa's model, we think that it could be a remedy to that issue. The way the model works is that we have 3 schedules where they would separate the offenses between minor offenses, moderately serious offenses, and most serious offenses. And that would determine whether the eligibility of the child to enter the program. Once the child has entered the program, then they would do their assessment, and the child would be placed on one of 2 diversion levels. And each diversion level would speak to the specific interventions and types of interventions that are expected to be carried out. Where level 1 would have more community-based and restorative measures, level 2 would have more serious supervision measures that would be more suited towards more serious offenses or repeated behavior.
And if I could just interject here, one of the justification for this is when you look at the eligibility of diversion in our legislation, it does indicate that if a child commits an offense within the 3-year period or 3 times, the child may become ineligible for diversion. And we understand that you don't want repeat behavior, but there are some instances that is beyond the child's control and more so lack of parental supervision, and we think that we have to allow space in statute to address these matters rather than having the ineligibility so defined. And we think South Africa's tiered model may provide some remedy in that respect by recognizing that some behavior and some context may require a little bit more rather than the time frame being so clearly outlined in the legislation.
Chairman.
Yes,
Ms. Jackson and Ms. Williams, if you can, assist me with the circumstances, just for wholesome. What circumstances do you contemplate that we would promote or accept the repetition of a particular behavior, because it becomes a modus operandi and there's probably a different way to deal with that. So what circumstances are you envisioning?
Well, for us, it was less about a specific circumstance, but more about the social context within which we know some children frankly live in. I heard member Dalrymple Filbert speak about, for example, the big yard families and the external influences for some children. If it is that you have such a context for a child, it's difficult for a child to thrive independently and to benefit from a program where there are external influences that could very well see that child coming in conflict or contact with the law. And we recognize that we're not promoting repeat behavior where the child got very good support and we have done all and the child is just resistant to reform. But what we're saying is that there may be social context beyond the child's control, or if a parent is not adhering to the recommendations, I don't think the child should definitely or definitively be at risk of not benefiting from the child diversion. So I think it's just based on having the law allow for a case-by-case approach rather than it's saying that you could be excluded with a three-time recommendation or within a 3-year period.
All right, we have 2 positions in this House, the Ministry of Education and State Minister Dalrymple, who advocates for the funds to be shifted to the ministry. But would you agree or do you appreciate that what you just said would indicate that the intervention that the Ministry of Education through CPSFA is promoting would be that when the child doesn't have the support at home and starts to embark on a particular behavior, that they may end up in state care? Or are you saying we should avoid that?
If I understand the question, is that based on the comments around expanding the diversion program to deal with other social interventions? we have it to speak to, and I would caution the committee humbly on that exercise, because I think we have to remember the purpose of the diversion program for children in conflict with the law, and that we're not duplicating the efforts of other ministries, and that the child diversion is going to become a catch-all, let's save all children. You have the Ministry of Education independently dealing with certain matters in a preventative way, in a holistic way, and I think, again, we have to be focused on what a diversion program is, and having less children go to the diversion program and more children benefiting from the interventions of the Ministry of Education in their capacity as the ministry dealing with youths and children generally. That's my humble opinion on behalf of the
and that's
organization.
a very good
Chairman.
point. Member Golden, you want to?
Yes, if I might. And Chairman, let me just apologize for being late this morning. I must admit I am absolutely regretting having to have come late this morning. But I wondered, and this is a question I'm posing to the team as well, the ministry team. In the look at the policy imperatives that informed the Act in its developmental stages, as well as in the very comprehensive recommendations that the ministry had given to us last week, are we including the science, the contemplations of the psychiatric and psychological professionals in these? I heard Ms. Jackson talking about just now the consideration of not barring that child from being dealt with in the diversion program, not limiting the instances when you can divert them on a case-by-case basis. What does the scientific literature say in terms of how we treat with those kinds of behaviors when they arise? And certainly the idea of a case-by-case discretion would treat with the factors surrounding the particular circumstances that are unique on that case-by-case basis. But there are a lot of lawyers in this room, and I don't. Are there any child psychologists in the room? Are there any at all? And Minister, I would wish that as part of the outreach that we did to get persons to comment, that we would specifically speak to the Psychiatric and Psychological Society, just to hear them opine. I know a few psychologists who deal with children who, are in conflicts like this, and I can hear them in the back of my mind expressing their concerns about Jamaica in that regard and the systems we have set up to support those kids. And I am also agreeing that we have to be careful that we are focused here in this bill, in this act, on children in conflict with the law.
Member Shireen Campbell Golden, I think it's a good idea what you've mentioned. If you have psychologists who would be prepared to give us a better understanding of things we don't understand.
Well, I'm asking for it as one of the legislators who are going to have to opine on this.
So what I'm really asking you is whether you could touch base with, you indicated one or two psychologists.
I know some, Minister, but the appropriate way is for the Parliament to write to their bodies. I'll suggest to the Parliament who they can write to.
What I'm really asking you, if you could touch base with them and see if they're prepared to come and speak to us.
That's fine.
And then we would formally write them.
I can do that.
We don't necessarily want to formally write them, and then they're not going to come. So if
I will make an.
If you would mention, and Mr. Nash would be willing to write them directly, but we also have a few psychologists, who we could invite because they have been working with us over the last few years. and who might give us a better perspective in response to the point that, you know,
And I'm going to make a
Justice-
further point after Miss.
Yes, turn on your mic. Could you turn off your mic? It's not coming on? He press it.
No, you. She press it one time.
Press it. Use the other one then, use the other. What is happening?
Oh, yeah. All right, so that one came on a while ago, Rodney.
Yeah, use that one then.
Mr. Chair, I just wanted to confirm that we do have child psychologists who are members of the child diversion committees across the island, so we can invite them to be a part of.
Okay, so we will do that, but that doesn't stop if you know of anyone in particular that we could invite. We would like, you know, good. I'm a lawyer. I know nothing about psychology.
And Chair, I thank you for that, and I want to make the further point that in relation to the decriminalization of I hate to say consensual sex, but sexual activity between minors. It's of great concern to me, and I really would want to hear this perspective of the psychologist, because as a mother of daughters and sons, I've always been uncomfortable with that particular, I'm going to call it the error provision, because of the message it sends young people in terms of how they treat with the idea of sex. And I've always thought this idea of shaming and punishing, and I think most parents who are involved will tell you that's not the way you teach sex education to children. It puts them, it gives them a whole different way of looking at it that I think ends up being having a negative impact in their adult life. So I would really want to hear the psychologist opine on that.
Sure.
And even while I have to tell you, Chair, it is really hard for me to move down this rabbit hole of all this policy research that has been done on the basis of a mistake.
Yes.
I have it hard, and I've noticed in this there's quite a bit of heavy lifting in this brief on the issue. You see how much effort it takes to correct a mistake when we make it?
Can you imagine? So as you know, where it's a matter that we should have addressed long ago, but we hope we can address it before or simultaneously with our report. Okay. All right, thanks. Continue now, Ms.
All right, thank you. So the next recommendation I wanted to highlight is similar to what Member Buchanan mentioned earlier, in that we wanted to see an expansion of the first schedule. This was partially because of the matters that we have been seeing, where we would see offenses like grievous sexual assault come up, and it is consensual between the parties. They're both minors. But of course, you can't get the early intervention because it is not a part of that first schedule that the police can divert for. We would have also consulted with the police, as Ms. Jackson would have mentioned, and in that consultation, they would have similarly had that recommendation to expand the schedule to include that particular offense. And another offense that they highlighted was that of Section 9 of the Cybercrimes Act that speaks to malicious communication. Apparently the youngsters are using the phones, sending threats to each other, sending each other obscene messages, and they are falling within conflict of the law. And so the officers would want, in some of those instances, to be able to directly send them to diversion rather than taking them through the court process that we know, even if you're going to get the diversion, can still be a lengthy process. Yes, cybercrimes. So I'll defer to Ms. Jackson for this recommendation.
So the matter of referrals, that was a big one for us.
No. Many
Yes.
people can't read, more so myself. What is on the screen? Is it in the screen? Is it in?
it's in
Is
the
it
report.
in the report? What page?
That's the brief. The report itself has, Jade,
No, what page? If you tell us the
page
page.
31 of the child diversion report. Our apologies. I also can't see a thing on the slide.
Exactly. So it's at page 31.
So if we bring our attention to the bottom right, that's where it speaks to referrals as the subheading. It clearly indicates that currently in the legislation, only the courts and the police can make referrals. And we are of the view that the Office of the Director of Public Prosecution should be empowered to make referrals directly without the support of the court or independent of the court. So if we read the legislation as it is currently framed, what it says is that a prosecutor can make a recommendation to the court for the court to then divert. But if we remind ourselves about the principle of diversion, we want to ensure that our children are diverted as early as possible. So if we recall the case of the young man that Ms. Williams made legal representation for, charged with grievous sexual assault, the police can't divert. The prosecutors would be minded to divert, but the prosecutor then has to make that recommendation to the court. So the child is not benefiting from the early diversion. Now, one of the things we know that the prosecutors can decide not to prosecute a matter generally, given the powers of the office. However, this is not a matter of whether they should prosecute or not prosecute, because we know that some children need to benefit from the diversion program. So we're saying as the law is currently framed, the prosecutor then has to make that recommendation to the court. And as Ms. Williams highlighted just now, that can be a timely process. So we want the powers of the prosecutor to be so expanded and reflected in the diversion. And this is not a new thing. South Africa has it, Fiji has it in their child justice legislation, and we're humbly suggesting that Jamaica so expands. We are also, the report suggests other referral partners, but in hindsight, I think we have to be careful as well that while we are still of the view that the Child Protection and Family Services Agency has to be reflected in the diversion legislation somewhere, and the Office of the Children's Advocate, Ms. Williams, will speak about where we are recommending for the OCA to be reflected in the diversion legislation. We would caution the committee, however, from expanding the referral process too much to other agencies and individuals, because I still think, and the organization is of the view, that sometimes casting the net too wide can cause further implementation challenges. So while they can be listed in a referral pathway in some guidelines, perhaps you don't need to have justices of the peace, for example, necessarily spelled out in the legislation, and just limit it based on the best practices that we've gleaned in other legislation. The police, the courts, and the prosecutors, in our humble opinion, would be enough to be listed as referral agencies.
Well, if I might say so, Ms. Jackson, that's the recommendation which is being considered. I don't know why you want to limit it necessarily, because you're only adding the prosecuting authority. But I think you're intimating maybe the office, OCA, the Office of the Children Advocate, could also be another
Minister, I really don't want to keep jumping over Ms. Williams' points, but to be listed in the legislation, I think under Section 10.
No, well, at the moment, the only two referral agencies are the courts and the police. And your report also felt that's too restrictive. I've always felt that's too restrictive too. And you're right, we can't just say say a GP or anybody can do a referral. No, it has to be one at an authority that once it's referred, it has to be in a manner so that the child can, put in bracket, coerce to benefit from the program.
Yes.
In other words, why the court and the police? Because if the child failed to complete the program, then both the police or the court can then take further action.
Yes.
So if you bear that in mind, then it will give you an idea of who else could be a referral agency. I've discussed with my team the possibility of a headmaster or headmistress. You know,
but I think the point, Minister, that
you know, that possibility, I don't know if that would be appropriate, but I thought that could be some, and in fact, well, you know, so the real issue there is we do have a number of children who are on the verge of committing crimes or unlawful activity. The only time they're referred is when they actually do commit the offense before the police and the court get involved. But you have these wayward children, if I'm using the term wayward, in schools in particular, that a guidance counselor would know and the headmaster, headmistress would be aware. And those children need assistance. Yeah, all right. One second. No, let me just have the members. First, go ahead, Ms.
I had my mic on for a different point, but I would like to respond to the one you just raised. I think we have to maintain clarity about the purpose of the child diversion program. And I don't think it is a child diversion program which should address that situation, which of course is of deep concern. I agree with you that it's important for us to prevent a child entering onto a pathway of activities which would cause them to be in conflict in the law. But I don't think it's for this program.
Okay.
And
Sure,
before, I was listening very carefully. And one of the things that concerned me out of your presentation was both the example of that young man on the honors roll, but you kept on saying that it is not timely in reference to the whole process. You used that word several times, and I wanted to know if you had carried out any analysis of the entire process from referral, and if you had identified some of the reasons for it not being able to be done in a timely manner, and if you had recommendations to address any of those processes which might need addressing.
In cabinet. The case that we made mention of, it's one, Ms. Williams spoke about it earlier in terms of the reports not being shared in a timely manner and so on. But we have anecdotally noted other cases based on the experiences of other attorneys, some of which would be reflected in our recommendations. For example, you know, the jurisdiction of the court at first appearance and so on. So we will take note of some of those recommendations as we progress. And if I may be permitted to highlight, and I'm happy that member clarified again the purpose of the child diversion program, and that within schools, the Ministry of Education, they have the school resource officers that are there. Yes, we know that some schools may require more, but I can tell you from experience, assault occasioning bodily harm and so on, the children are just fighting in schools, as we know. And the principals have done very well where they establish relationships with the police stations. So the point that we're making is, Minister, is that not everything needs to be in the legislation. And by the way, at JFJ, we're cautioning on ourselves with that as well. Not everything needs to be spelled out in statute. How do we create guidelines, partnership, referral pathways to ensure that if a school, based on the challenge of a child who is placed on the Dean of Discipline list, for example, displaying behavioral challenges, again, that's not the jurisdiction of a child diversion. What other social programs exist that the school resource officers could intervene, and the police with their own program can also provide support. So I offer that caution to the committee that we're not trying to do all things, because we do have other ministries with their areas of responsibility as well. Over back to Mr.
Sorry, you go ahead.
I'm hearing you clearly, Ms. Jackson. Now, my thing about it, Chairman, the purpose of child diversion is an introduction for children with conflict with the law. Have you contemplated, as the Chairman would have suggested, a pre-diversion mechanism within that? That's one question, because would a schedule to correct the mischief in terms of the referral mechanism, in terms of a principal, a dean of discipline, and even guidance counselors are the first responders to behavior, conflict within the school, a particular environment. I won't name schools, that they are best in a situation to kind of intercept. You don't think by either regulation or a schedule in the act itself to identify the persons who can say, listen, we're sending this here because conflict with the law means that in the alternative there has to be a charge and then brought to the court as the legislation now is drafted. So if we're going to contemplate or reconsider what the new sections would look like or the schedule, if that's something you had thought about.
To answer that question, I think we first have to look at what exists across the ministries. And we were also at great pains, and even listening to the committee at its last meeting with decriminalizing of sexual activity among minors that is consensual. And I think, again, what is the appropriate mechanism? So, for example, the young honor student, digital penetration, and what is normal adolescent behavior. The program can't be everything to all persons. Is the child diversion program the best program for that particular child, for example, versus a child who perhaps fight a lot in school, who perhaps in one of the fighting incidents pulled a pencil because the next time that child could pull a knife? Is that child better for the child diversion program? But again, what other programs exist? We have the Health and Family Life Education Program. The school resource officers are there for a particular reason. The guidance counselors are there for a particular reason. Are we duplicating efforts possibly by expanding the child diversion program and doing the Minority Report, the movie Tom Cruise? I'm a movie person, forgive me. So we're looking futuristically on things and perhaps utilizing the program in a way that, based on international best practices, that is not the purpose. And we know we can expand based on our own context. But my humble suggestion to the committee, let's look at what already exists. Perhaps as you expand others to speak, the conversation could be had with a school principal, a school resource officer. I know DSP Shand of the Community Safety and Security branch of the JCF perhaps could be a good person that the committee could invite to get a sense. Mr. Richard Troop of the Ministry of Education as well could give better insight. But my humble suggestion is, let's look at what exists and let's not duplicate efforts, because the child diversion could offer an option for some things, but I think we have to look at what already exists and whether or not those programs need to be sufficiently scaled up rather than scaling up the child diversion program in some respect. Though I think, and I support more resources, certainly, Minister, for the ministry to do restorative justice initiatives and so on. But I think we have to be careful.
Okay, go ahead, Ms.
Ms. Williams, before I throw back to you, there's just one thing that we try not to miss. We're starting on the premise of the best interest of the child. That concept is codified in legislation, the Child Care and Protection Act. So we have a situation where that very act puts a duty on society in general, who has a duty when there is harm to one child, if we use the scenario of female by virtue of, against another child who happens to be male. There's a duty to report. The intervention that we speak of, even though we're not ramping up or minimizing other areas, the very legislation, and I spoke to the staff at the Ministry of Justice on the very first day about Section 34, because the Diversion Act actually contemplates uncontrollable minors and how to treat with them. So there is a clear definition, and I'm just asking these things so that we can be guided in terms of when we are deliberating on what it needs to look like.
Children in need of care and protection. And my concern again is that I think we have to be careful about the purpose of the child diversion and whether Section 34 should have existed at all, and whether or not Section 34 needs some amendments. So Ms. Williams, she actually has a slide on Section 34, and perhaps this is where the role of the Child Protection and Family Services Agency would be appropriate in the legislation, because we have to be reminded, purpose of legislation, best interest of the child, and what is an appropriate intervention. And as parents, we know that sometimes some of the actions our children do, technically speaking, they could be classified as uncontrollable, the slamming of the door when you speak to them, the hissing of the teeth. It is so wide and encompassing that we have to be minded of what is in the best interest of the child, but also what is the more appropriate social intervention by which particular agency is the point.
Right, and I think it's very important we get the right balance. And that is why, Minister Dixie, I'm sure you'd like to come in.
Yeah, thank you, Chair, and I want to thank Ms. Jackson for your comments. What I think is very clear here is, everybody is very much minded to take care of all of our children, and we understand that there are a lot of issues around our children. But I think what's been missing a little bit, and I think after our last sitting, and I thought about it, I felt that what's missing is really that mapping of what exists. The legislations, the various legislations that we have, and the various entities and what their roles and responsibilities are. Because when I hear what they're doing, what the child diversion team is doing, it's beautiful. It's beautiful work that's being done, and you wish, that kind of approach could be taken elsewhere. But we're dealing with a particular piece of legislation that is about children who come in conflict with the law. And so we always have to remind ourselves of that narrow context within which we're operating, but we do that understanding the lay of the land, legislatively and otherwise. And that's, I think sometimes we are, and it's easy to do it, conflating different things, but I think we have to really be mindful. CCPA, the Joint Select Committee, is going to come. So we'll get to discuss some of those other things under that umbrella, but let's just focus as much as possible on that.
And colleagues, I think, the discussion is good. Obviously, there's a gray area between what is for child diversion and what is for CPFSA. And the narrower that gray area is, the better. But there will always be that gray area, okay? So we just have to be careful, we get it right as much as possible. Okay, we go back to Ms. Williams.
All right, thank you, Chair. So the next recommendation that we speak to, we did have slides on uncontrollable and decriminalization, but we did speak to it and we did share information on it, so we'll move on. The next recommendation that we'd speak to is that relating to guilty pleas. So under our legislation, we have the child accept responsibility, which is a necessary part of the process to be rehabilitated, right? You would have to accept responsibility for what you're accused of. However, the acceptance of responsibility, what we've been hearing at JFJ is that some courts have misinterpreted what that means. And so before the child is recommended or is placed on the diversion program, the child is made to plead guilty, right? Rather than accepting responsibility, which is what the Act intends.
Section in the Act that is again.
You're dealing with, the section you're dealing with.
1 second, please. Yes, it is Section 9 that speaks to your eligibility under the Diversion Act.
Okay. All right, continue.
Yes, so our recommendation really, because we don't think that it's a matter of the legislation not being properly constituted. We think it's clear in the legislation what it intends to do. But since we continue to see this challenge, our recommendation was to amend Section 10, which speaks to the protection of the child from that acceptance of responsibility being considered a guilty plea, to add a subsection 4 where we would specifically say to the court that they would adjourn the proceedings in order to recommend the child to the diversion and that they would not accept a plea as a part of that process. It's not in our, just to be clear, that is not in our report. That would have been something we considered before we came before the committee. Another recommendation speaks to the eligibility, and this is different than the recommendation Ms. Jackson spoke to. If you don't mind,
tell me the page if you're reading from your report, because I can't read anything up there. Oh, that's not in the report.
Said it was a consideration after.
So no, I don't believe this one is in the report either, but this one is also a consideration we would have had before coming before the committee. Some of the data that we received would have shown where persons were recommended to the program, and the reason that they did not finish the program was that before they were able to start, they aged out of it. And so they were now adults and no longer eligible to participate. So our recommendation is that, similar to what we have under other legislation, that we would consider the time that the offense was committed rather than the age of the perpetrator at the time that they are now entering the child diversion program. Within that recommendation, we would have said that you would want to consider this up to the age of 21. So say, for example, you commit an offense when you are 17, and your assessment, you're not able to enter the program until you're 18, you would still be able to enter the program because the offense was committed when you were 17. Right? So that is one of the recommendations that we had.
I'm sorry, Chair, through you, just to understand. So I commit the offense at 17, I turn 18, I'm now an adult, and I should be eligible for being diverted into the program, is what?
Yes, that's the recommendation.
So what exists now?
So what we have been seeing happening is that you commit the offense at 17, but you are before the court at 18,
right.
And now the court is going to consider the diversion, and when the court looks at the act, it says you're not eligible because it's 12 to 17. So the court continues with the matter as through the normal legal process.
But I'm trying to grapple with how you then put an adult into a child diversion program at that stage, or whether is there another type of program we have where persons like that could be diverted or could be directed, because you don't divert an adult, you direct, you order if the court is acting. But I don't know that you can divert an adult. How do we, it sounds a little problematic to me, but I understand the issue.
I think your question is quite appropriate, because it's a challenge that I think it's a challenge even the committee has, in that, yes, the offense may have been committed, and when the offender, let us use the term offender, is say 16 and a half, 17. But by the time it gets to court, the person may be 19.
And you know, Chair, I want to appreciate this too, that the magic that happens, as I am going to experience for the third child in my family, on when you turn 18, is really no magic. You know, they were a child the day before with the same mental capacity. They remain with that same mental capacity, though they have attained legal, the age of adulthood legally. But it's not a child program at that point. So the point I'm making is that, you know, if we're going to call this the Youth and Child Diversion Program, then maybe we can find some carve-out in it. But when you're going at 18, 19, 20, because sometimes it takes a long time to get to the court process. So if the police haven't diverted you and the matter is taking an extended time in the courts, what you do with that? No longer a child at 19 who could benefit from the interventions. I don't know that this act really is a place you capture that person.
All right, we're getting a little bogged down, but no. In all sincerity, we need to sort it out quickly. No,
Real quick.
One second.
Chairman, if I may, because we raised this on Tuesday, and there was a suggestion, and I think we were consensus at them where this was concerned. We were in agreement where this was concerned, because the Privy Council ventilated this issue that when the person is charged, it is the charge date that makes you qualify.
Exactly.
The Constitution also, when we talk about equality before the law, equitable treatment before the law, you can't take away a benefit. And we have one of the biggest constitutional relief that the courts is taking on its own initiative to award to even adult defendants.
No, I was going
is a relief for delay. It cannot be that our system is bogged down.
Member Buchanan, I was going to say that I think.
Okay, no, I was just making that clear.
That if the charge date was that when the person is a teenager or 17 and under, it is the appropriate time to decide. So even if the person was 19, then the person is still eligible for the child diversion program.
But Mr. Chairman, this is the need why I'm going to even stress more why that has to be codified so that there's no issue or mistake.
And, you know, may I just say, though, Member Buchanan, it's unfortunate that if a person commits an offense at 16 or 17, why the charge or the matter should not be referred by the police or the prosecutor within a matter of a few months. It shouldn't be taken a year or two. Yes, sir.
Yes, one thing I had wanted to note is that this is an issue that is not exclusive to the child diversion, and Mr. Buchanan would be very familiar with this. So especially in the parish courts, it is ongoing.
Well,
one thing that has been implemented recently is that there is a fast-track list in the parish courts for certain matters to be placed for the more efficient dealing.
And as you quite rightly say, and we had explored that possibility, that anyone who has committed an offense as a teenager, we should quickly get them to the family court or to the parish court sitting as a family court.
Yes,
you understand?
I think that
so that is something which I certainly will want to discuss with the Chief Justice, so that once a child is an accused, that they get to the court within a matter of weeks rather than
months or years.
Okay? All right. Yes, Mr.
So, Chair, I wanted to just confirm, and I agree with...
Go a little closer. Why don't exchange seat with Mr. Levy?
It's probably a little challenging. Let's see.
No, man, you're slim enough to... I don't know, what is wrong? I mean, is it where Mr. Buchanan sits during the day? That he has damaged a microphone.
Thank you, Chairman. So what I wanted to clarify was currently...
Sorry, go ahead, sorry.
Currently what I'm saying...
I don't believe you.
Let man. Is this working? Can you press it? No, let man. This one. The other one here. This one.
Let's see if this is better. Yes. So, Mr. Chairman, I was just clarifying, currently what obtains within the child diversion branch is if the offense was committed prior to the child turning 18, and they're willing to be a part of the program, we accept them into the program.
So,
the issue is, though, that it's not clear in the legislation, so we're asking for it to be clear there so that when it is being treated with, they don't have to second guess what happens.
Ms. Samantha, make a note of that first, how we clarify that, please, okay? Thank you. Okay, now before you continue, Miss, I just would like to welcome from the Mineral Heights Primary School, that's Wayne Clarendon. There are 136 students, 17 parents, and 8 teachers. So welcome to the Parliament. This is not the normal sitting of Parliament. What we have here is a joint select committee consisting of some members of Parliament on my right, and on my left are members of the Ministry of Justice and also Jamaicans for Justice. We're going through the Child Diversion Act. I hope none of you children will ever be in that program, but listen as to why you should not be in that program, okay? Thank you very much. Welcome to the Parliament. Continue, Mr. Sorry, before you go.
Can I just also add to what you just said, just for the students' benefit, that the Joint Select Committee contains members from the House of Representatives as well as the Senate. And so there are both members from both houses here, as well as opposition and government members as a part of this committee.
And you notice how friendly they are. They sit with one another. All right? Don't think that they are loggerheads, please. Okay? Thank you. Go, Ms. William, go ahead now.
Thank you. So the next recommendation that we had was speaking to the matter of jurisdiction. One of the challenges that we have been seeing is generally we spoke to the delays in the court process, but also that because we are seeing so many court dates and the court has not accepted jurisdiction, there is a continued challenge with how the cases are managed. So our recommendation was that once the child is before the court below the age of 18, that they would be, for a minor incident, they would automatically be in the children's court jurisdiction, that the court would not have to accept the jurisdiction for children's court, so that they can be treated in that way generally. And also to impose a duty on the court in that instance to consider diversion in the first appearance. Yes. Yes, so this recommendation now speaks to the rights protection, and this was where we considered the Office of the Children's Advocate. So what we saw in Fiji's legislation, their Child Justice Act, they allow for the child to receive legal advice before they join the program so that they are fully aware of what joining the program would mean and what those obligations would bring. So we made a similar recommendation in that the Section 10 of the legislation would be amended to allow for the child to seek legal advice before they accept responsibility or consent to being on the program. Even though their parent or guardian must be there for them to consent, we also recognize that a parent or guardian may not always have the understanding that we would expect them to have in order to properly give informed consent to their child being on the program. So that was one recommendation that we took from the Child Justice Act in Fiji. This recommendation came from our consultation with the JCF, in which they would have highlighted the informal warnings that are a part of the police diversion options under the Child Diversion Act. While the informal warnings are sent to the diversion, should be sent to the diversion office as a record, the police themselves are instructed to not to keep a record of the same warnings. It was their recommendation that they keep a record. They think it would assist them in allowing for earlier interventions to be given. The police also make referrals to like Child Protection and Family Services Agency as well, and they consider that having those informal warnings recorded would allow them to make those referrals more earlier, and therefore the child would be less likely to continue on a path of criminal activity.
Can I just ask, have you assessed that desire and that recommendation with the Data Protection Act? And I ask in the context, I'm not quite sure what that record would, what information that record would keep with the police, and how that record, which is an informal warning, would sit in relation to that child in the future. If the police has a record and that child eventually becomes a defendant in their adult life, what's the impact of that record with the police, particularly because it's an informal warning? I just wondered if you'd assess that. If you haven't, fine. I'm poking and hoping that you'll talk about it at another time.
Chair, I had a concern also on that one, because last week we would have, not last week, this week, we would have spoken about adverse findings on when individuals were going for employment. And my concern is that in the police keeping these records, that I'm going to be scarring these young people later on in life. And so I'm very hesitant with this proposal, because we really do want to be able to have these young people who may be in conflict with the law, they may be in conflict at that time, but that doesn't mean they will forever be in conflict. And through the diversion program, we are trying to get them on that right path, and I would not want a record following them like that.
No,
Chair,
yes.
I want to agree with the minister, because always we need to balance our objectives. And although it is that you're saying, Ms. Williams, that this will assist in putting them into that program, I think that the whole issue of the adverse trace means that we ought not to proceed along that line. Because if it's in the best interest of the individual, on the one hand, here it is, yes, you might be able to act quickly, but on the other hand, it might have a lasting negative effect, which is not what we're seeking to do.
Thanks, Senator. Yes, Member Buchanan.
I was joining with my friends to say that in treating with minors generally, and the legislation actually speaks about the secrecy of proceedings and the reporting. What we're finding now is in the new modern dispensation, these adverse traces are showing up, and then the state cannot even account for who is sending it, who has it, and when it's out there, discrimination takes place. So juvenile records are sealed. The proceedings are in camera for a reason. What happens now in the courts is that when a child is before the court, a judge immediately clears the courtroom without you even hearing the child's name, and you have no idea of what the proceedings is, even in what we call big people court. So in the best interest of the child, it ought to even be a criminal offense for adults to expose the proceedings. I won't take it that far because I'm not into criminalizing every single act, but just to say the importance of protecting children and recognizing that as we are treating them as children, they will make mistakes, and I think the object and purpose of the legislation is for corrective mechanisms. So probably that wouldn't be the best approach, but to find a way to say that records and stuff is not kept, especially where we would be able to trace it at some point.
Right. I mean, to be frank with you, Member Buchanan, what you're saying is exactly the position, because you don't want any record. And in fact, many of those records are actually transferred to the main institution once they reach a certain age. So I think, I mean, this has always been the position. We're trying to see as best as possible for the child not to have any engagement with the traditional institutions. So that is the effect of what we're trying to achieve. Anyway, we continue. It looks like you're going to be here with us all day.
I don't think so. We only have a few more recommendations to go through, but we thank the committee for their comments on that previous recommendation, and it's something that we'll consider thoroughly. Thank you. So the next recommendation we considered was to look at currently under the legislation where the police are the persons to refer a child to the diversion program, they must receive the consent of the victim. And if the victim does not consent, then they have to proceed to court for the court to reconsider the matter. Our recommendation is that for particularly low harm instances, so, you know, instances where it's a fight at school or peer disputes or property damage, low value property damage, that the consent of the victim is not necessary at that level, and that the police would be able to proceed with the diversion regardless. Okay. All right, so as far as children in need of care and protection, this was the Section 34 recommendation that we spoke to earlier. And it looks at treating with children in need of care and protection under the diversion program. And our concern was that we would be processing cases that are mainly for welfare through criminal justice mechanisms, and that we would not be able to use the Child Protection and Family Services Agency as the first responder for those particular welfare cases. So our recommendation was that in looking at Section 34, we insert the Child Protection and Family Services Agency as the agency where the referral is made if the child is primarily in need of care and protection. And that should a child be sent for diversion, for example, and it becomes known that they're in need of care and protection, that recommendation is made to the Child Protection and Family Services Agency. We also recommended that the Child Protection and Family Services Agency be given what the prosecutorial body has now, which is a recommendation role, in that they could recommend to the committee or to the court or to the police that a child is in need of going onto the child diversion program, and then that appropriate body can make the referral as under Section 9. And then our final recommendation that we would have highlighted has to do with the role of parents and parenting support. And we do know that, generally speaking, when programs are instituted, parents and the consideration of family life is taken into account. However, we are concerned that, and it's not just a concern that we've raised, we've also seen it in the consultations, that children successfully complete the diversion, but then the home life or community life that they re-enter brings them back into conflict with the law. And so we considered if there is not a role for parents in particular under the legislation and specific responsibilities for them.
Just to indicate that we do recognize that one of the child diversion options speak to family. It's there. But when we consider the framing in other legislation, it's a little bit more spelled out. And we know that the ministry, they're doing extraordinarily good work. But could the legislation be expanded a bit or should we be looking at more guidelines to spell out these things and ensuring, for example, the National Parenting Commission has a greater role to play? Because I tell you, some of these parents, they need rehabilitation, to put it mildly, and I don't know how we can deal with those matters. But we're not putting it in law.
All right. Before, there are a couple matters that I would like to ask you, Jamaicans to Justice, and for us to contemplate. Last time we heard about persons who have gone through the child diversion program, succeeded, went to work, only when you do further investigation, they have adverse traces. And I suspect the reason why they have the adverse traces is because they went to the court and the court has put it in their document, in the book. And so Ms. Jackson's recommendation that maybe it might not be a bad idea if the prosecuting authority, rather than taking it to court to ask the court to refer the child to child diversion, if they can exercise that authority and send the child to child diversion, obviously going through the same process without asking the court to refer. Obviously, there are some matters in which they will refer to the court, but to give them also that authority, because that would avoid this idea of adverse traces. An alternative to that is that if it goes into the children's court, family court, then the likelihood is that it would not come up as an adverse trace. But we have had this experience, which I think we have discovered, where the person having gone through the program, but because they were referred by the court, when the investigating authority did it for the relevant employer, then realized that the child had been charged with an offense, and therefore the child suffered because of that. Yes. So I'm just wondering if our members are asked Jamaicans of Justice if they ever put their minds to that, if they, in your investigation, if you know of cases that the child suffered adversely, even though they have completed the program. 1 second before you go.
I'm gonna yield to Ms. Jackson, and I'll comment after.
Okay.
Thank you, Member. Not for employment purposes, but for school reintegration purposes, where the participation in the diversion program has led to attorneys reminding schools about the regulations and so on by which they should, act within. So that is something that one should consider, and I'm not sure if that's necessarily a legislative matter, or it's more public education and holding the institutions, the educational institutions.
You're quite right, Ms. Jackson. Minister Dixon, I can tell you, I know of a few cases where the child has recovered fully, but because of what happened in the school, they refuse to take back the child in that school, and the child has to go to another school. And I'm just wondering, how the second chance should be given, to that child. And it is something which, as you have pointed out, and I know of cases where it has brought to my attention, and I've had to beg a headmistress to take a child because the child was in another school. Yeah. And the school just said, no, we don't want that child back. Sorry, Senator Campbell, then you, Minister Dixon.
Chair, I would offer this for our consideration and further deliberation at the appropriate time. It reminds me a bit of the Expungement Act, which we just, the Criminal Records and Rehabilitation Act, which we just passed amendments to in the Parliament. And in that Act, we have a provision that prohibits an employer from discriminating against a rehabilitated person on the basis of this expunged offense, because these things do come up in due diligence in investigation reports. It struck me last week when we had the conversation of these adverse traces, and Senator Dixon referred to it this morning, that a provision, a similar provision, may be required, because certainly in relation to the schools and the entrance of a child, and not wishing to admit a child after they've been through the diversion program, I think it is far more easily caught because of the process that ensues in a child seeking to enter that school. Where it is not likely to be caught is in the employment situation, and which may be why you have not had the experience of those kinds of reports. Because when you make an application and you go for an interview, the process of the decision making is not something disclosed to the applicant. Certainly not in the private sector. Perhaps in the public sector, one could inquire and seek to determine whether the process was fair or applied prohibited considerations. But you can't do that in the private sector. So I think that kind of provision should be within our contemplation to deal with that, because I'm not sure that you can completely, you can't enclose the fact of the child being in a diversion program or being diverted in secrecy. This is Jamaica. The neighbors know, the next door neighbor know. So even if it is not on official documents, people know. Right. And when the private sector does their investigation and their due diligence, and I've worked with some of these private investigators who do it on behalf of companies and so on, they're asking everybody, they're going to the neighborhood, they're talking to these people, and that doesn't reach the officialdom of propriety in terms of disclosure and secrecy and what shouldn't go forward and so on. So for our consideration at the appropriate time.
Thanks, Member. Minister Dixon.
Yes, thank you. And Chair, I actually agree with the line that Senator Golding Campbell is going down, because this, I do think that we have to, as a matter of first principles, agree that second chances are important. And I think that's what we did with the Expungement Act, what we call the Expungement Act more popularly. And I think that in terms of second chances, it's even more important in the case of children. And so hearing you speak of the issues of children who have successfully completed the child diversion program getting into school, that's obviously a concern to me. And it does speak to the fact that we have to do more public education in relation to the child diversion program and the successes of the child diversion program, so that our principals understand that this is something that is actually very positive, and these children can have a positive impact in schools. And in terms of the Ministry of Education, we obviously are based in the notion that every child has a right to education, and so we cannot, because of any issue, whether it's interaction with the court or any other issue, deny children the right to education. And so it's something that we'll look at, and we'll see how we can address it.
Yes, Member Buchanan.
Thank you, Chairman. Just to respond, there is a section 39, and possibly Ms. Moncrief, or I can't see my friend at the back, but it says, subject to subsection 2 and 3, every person having an official duty or being employed in the administration of this act shall regard and deal with as secret and confidential all documents, information, or records obtained relating to a child referred to the Child Diversion Committee for participation in a child diversion program. We possibly, or we ought to just amend to expand in terms of who would be covered under the obligation to secrecy, including the private sector. And here's why. The obligation to secrecy and confidentiality imposed by this section continues to apply to a person despite the person having ceased to be appointed under or employed in carrying out the provisions of this act. And then 4, subsection 4 says a person who contravenes subsection 1 commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $2 million or to imprisonment for a term not exceeding 1 year.
I'd go further than that, though, Member Buchanan, because that is dealing with perhaps persons
who work, which I said the amendment would come after subsection 1.
I would go further than that. Let me ask the members from MOJ. When a person has completed a child diversion program successfully, whether referred by the police or the court, how does the public at large know that that person, in a sense, has completed the program and, in a sense, should get a certificate to say that the program has been successfully completed? Because what members are saying, if the person has completed the program successfully, it may well be that the legislation could say that any charge that was before should now be null and void. In other words, because the program has been successfully completed, and therefore you neutralize whatever charge.
Minister, Chairman, respectfully, we're trying to say that the engagement with the program is secret. So a certificate would only be like, oh, you know my secret, here's my certificate, don't use it against me. The strengthening of the legislation, as Senator Golden Campbell had suggested, which we ought to adopt, is to amend to say that the seriousness of this, and because the state is strong about second chances, is that you are committing a criminal offense, and to hold it against them, which is discriminatory, having completed and having gone through the program, you're dealing with information which is a breach of the right to privacy of the juvenile as he then was, and we have to take it as serious as that to say that there is a fine and there is a sanction, and employers beware that type of discrimination, because we cannot, the state, respectfully, the state cannot say who this private investigator is who knows to dig up information, as in going to neighbors and Miss Matty say, yes, man, him did do this and do that, and they just hold it without concrete record. So it is actually persons being a gadfly, persons who are digging up information, and that adverse findings, which is what they call it, is not attached to the state, respectfully.
Okay. Sorry, remember.
Chair, I actually wasn't sure that my colleague and I were on the same point, but as he was wrapping his comments, I think we are one on the point. It's not about the secrecy, it's about the prejudice that could be attached to that person after they have left the program. And you can't capture that in a secrecy clause. You have to deal with it as a matter of a discriminatory or an anti-discriminatory clause, or a protection against the prejudice that would flow from that. So I think Member Buchanan and I are
that is why I'm asking the ministry, how do an investigator, for example, who does investigation, should at least be aware that the program has been successfully completed? How would an investigator know?
But that's it's not relevant though, Chair. Huh? It's not relevant though, because the investigator, having done the investigation and come up with those findings, breaches nothing unless the findings are applied. So the issue is not the knowledge, the issue is the application of those in a prejudicial way to the child who comes into employment or seeks to go to another school. Because I don't know how do you legislate that when you are not quite sure who you're legislating against. This secrecy clause at 39 captures the administration and people who work in the system. It don't capture his neighbor. And the neighbor has no obligation to keep his business secret. And particularly if the child himself or herself, let me be gender neutral, has disclosed the fact of their participation in the program to third parties.
Okay, let's hear. Yes, Ms. Clark.
So, Mr. Chairman, what currently obtains, we ensure that the information that is provided once a child is referred to the program, it's confidential. So you cannot call me, even as a minister, and ask me, Vanessa, is Mr. Rodney in the program and where is he and so on. There are many children in the program that I don't even know about. Once they complete the program, the entity that referred them to us is notified that the child successfully completed the program. And this is important because it enables them to dismiss the matter if it needs to be dismissed. Also, the child receives a completion letter to indicate for their records that they have completed. But outside of that, we do not give that information to any other party.
But how do we avoid the prejudice to that child? Sorry.
If I could just ask a question, and this is also for the benefit of the public as well. When a child is brought before the court, that matter already has a case name, does it not? And it sits on the official record of matters before the court, correct? So the dismissal of that matter is a matter of public record. So we already have some suggestion to an employer that John Brown was involved in a matter before the court, so the matter was dismissed. It raises a question, right? If I'm an employer and I determine that you were involved in this matter for whatever the offense was, it raises a question for me as an employer. So we start with that. So I'm saying, and I think Member Buchanan was joining me, or I'm joining him, in saying that the focus is not on the secrecy. It must be on preventing the discrimination. And as much as this clause deals with the secrecy with Vanessa and her colleagues, it doesn't deal with anybody else in the neighborhood. It doesn't deal with a classmate who the child was in school with. And I don't think we want to go down the road of putting in sanctions that are, well, I don't know, they would really be criminal sanctions, I would have to think. We don't want to go down the road of sanctioning a child, a third-party child, who has repeated to somebody else, hey, my friend John got arrested for this, you know, and he went into this program and him come out now and him nice and cool, you see him calm down. I don't think we want to do that. The mischief that we are raising is the possibility of having successfully completed this program, or quite frankly, unsuccessfully as well, because I don't think that whether you're successful in the program or unsuccessful, the essence of the program is that it must be a secret, confidential matter. So once you have completed that, the mischief we're trying to guard against is that it does not, as Senator Dixon said, prevent you from accessing second chances. That's you know, essentially.
What I'm really trying to determine, without saying that we have to make a decision, but some suggestion, how do we make sure that after a child has completed the program and clearly has gone straight, let us put it no lower than that, that it doesn't come back. What happened before doesn't come back to affect that child. You see, and the question, as you mentioned, expungement as an example. How do we, when a child has completed the program, yes, I listen to many children who are happy having gone through the program, but can you imagine later on it was told that they were involved in some indiscreet or some misconduct, when that should really have been put behind them.
But told to who, Minister? Told to who? Told to who?
Well, you know of these cases, with the adverse cases where sometimes the private employer go and investigate and found that the child had been charged, for example, or schools that refuse to take back that child, even after the child has gone through the program. So what I'm really saying is that when you see many of these children who, and I've met a few, who have gone through the program and are now happy going forward. You don't want anyone to come and say, but wait, you were involved in that thing a couple of years ago. Can I just take Ms. Jackson, then you, Senator?
Thank you so much, Minister. I listened to the conversation, and clearly we're in agreement. But the Data Protection Act, by extension of its obligations on institutions, would also remedy some of the concerns about the secrecy and confidentiality. But I do agree with the member's intervention about the prejudice that may very well stem from the use of the information. And currently, as we were having the discussion, I think that's a bigger issue that is outside of the framework of the child diversion legislation, because even the Data Protection Act, it provides no remedy if an individual were to share information about another individual, because it is confined to institutions. And I think that's a bigger concern that the Parliament must look into as soon as possible. Mm-hmm. I don't know.
Senator Scott Martley, I don't know how.
Ms. Jackson's comments has addressed some aspects of what I wanted to point out. Because when we are looking at legislation, we can't legislate for everything.
Right.
And we certainly can't legislate for what our community and our neighbors do. So I think that we need to focus on exactly what is a mischief that we are trying to address, while recognizing that even though we might identify a mischief, we can't necessarily address it in the law. And that sometimes it is a socialization of the community and indeed the society where we have to look at. And the public education program, on which I'm sure the minister is going to embark, would naturally sensitize persons in this regard as to the need for utmost confidentiality, but more significantly, as to the need not to use this in a discriminatory matter. And to remind them that they themselves, when they were children, might have done things which have offended the law, but they would not want it to be held against them. So I think it is more the national conversation which will have to address these matters. Because if we were to address all these matters in the law, Minister, it will be unwieldy.
Good point. Thank you, Senator Scott Martley. Yes, Ms. Letman. One thing.
An issue if we wanted to undertake insulating individuals from social consequences as well as the consequences of institutional exposure, because I think those are two different issues that we are conflating that I don't think are necessarily the same. So if it is that somebody at the ministry, for example, decided to say, oh, this person was involved in the child diversion and they came out of it well, that would be one thing, but I don't think that's, as the member said, we can legislate away the social consequences of having perhaps done things that, you know, may not be on the straight and narrow.
I understand. It's just how we avoid the transmission of that information. Yes,
but that may be impossible, unfortunately.
I'll just say this, Chairman, the aspect, and I'm going to say this, that the Expungement Act, the expungement legislation, it sets out clearly that it is a criminal offense if you are not an authorized person to disclose, which is why I'm saying an amendment to Section 39 would cure the mischief. And here's why I'm saying this, Chairman. It cannot be that persons are allowed to reign free, and the Expungement Act accepts that and actually has a section that says if you do this, here is the fine, here's the charge. Whether or not persons, whether or not they are charged and brought before the court is another matter in terms of enforcement, but this aspect of it is something that we have to legislate against it, because we're in a modern dispensation where I can tell you this, even after these persons move on with their lives, as they advance and they become productive members of society, social media can be very unkind, and there must be consequences.
Quite.
I'm just on this, similar to how if you share images of so under the Child Pornography Act, for example, it's the same thing. So disseminating information. So that could be perhaps a framing from that legislation, given the sensitivity, Minister.
Right.
That could be looked into.
So what I'm going to do, obviously we will be deliberating this at a later date, and the law reform personnel and other Attorney General chambers, they're here, and also the drafters. Bear that in mind, some of the discussion, because when we start to deliberate, we're going to be asking for guidance from you, the Ministry of Justice, Attorney General's chambers, law reform, how we move to, if we can do any tweaking of the present bill, because that's the idea of how do we upgrade this bill, all right? And whether what members have been discussing and what has been brought to our attention by Jamaicans for Justice. We, Ms. Jackson, on your committee, we wouldn't mind. You have heard the deliberations. If you have any suggestions further, you can always pass it on to either the Ministry of Justice or to Mr. Nash when we come to deliberate. And obviously, PBCG apparently carries this program, or you can go live stream. I'm sure when we meet, and you will have an idea of when we are meeting, to follow the program and follow the various other suggestions coming from different entities. Because at the end of the day, we would like, you know, the best ideas to put into the effect, so better outcomes can be had from a revised Child Diversion Act, okay? So you're finished basically, and
Committee. Oh, thank you so much. Just want to extend our appreciation for the opportunity to make our presentation. We did not do a written submission because the recommendations came from the report, and normally we try to give a little bit more detail rather than saying go to South Africa, this particular section. So if we're so permitted, we would share a detailed submission. I know Jade is giving me a side-eyed view on the work, but I think it's important, so there is clear reference. Thank you so much.
Chair.
Oh.
Yeah, same school, but different, more students.
Oh. If you don't mind, if I might just interrupt. Go ahead first. You go ahead first.
I was, well, Chair, no. Let's welcome our guest first. And then
All right. I understand, you see, that these are students still from Mineral Heights, am I right? Apparently, the numbers were so high that only half of them had to rotate. So they have not really had, at least the important thing is to welcome all of you students. And to let you know that it's a sitting of the Joint Select Committee looking at the Child Diversion Act, okay? And on the right are the legislators from the House and the Senate. And on the left are presenters from Jamaicans for Justice and also members of the technical team from the Ministry of Justice. So we welcome you to the Parliament. I know many of you are coming here for the first time, and I hope many of you will return, maybe not only in the gallery, but maybe on the green benches here. So students, when you're here, you look at what is happening in the Parliament, and you can see it's a very peaceful gathering in the Parliament. Not what you occasionally see on TV. If you notice, both government members and opposition members are here because we're looking at a particular piece of legislation, and we're trying to get the best information so that we can put together an appropriate amendments to the Child Diversion Act. So welcome to the Parliament, and I hope, although you're late, you will enjoy the remaining time that you're here with us. Yes.
Chair, I would like to make an intervention in relation to our process because already I have one, two, almost three very thick documents in this file that the Parliament has prepared for us. I'm not walking back on my congratulations from last week. Please don't misunderstand, but I think we have made an error in our process. Because while the ministry's submission covers the issues and the recommendations, where we really probably should have started, and I don't think it's too late for us, is to ask them to take us through the act. We are here discussing provisions that we're kind of trying to grapple with what provision this is and where it falls. And so I see my colleagues nodding.
Sorry?
They did take us through the act.
Okay.
And I go further. They're going to do so again. In other words, it's clear, and I've asked them to
in
note.
relation to their presentation?
No, they did initially.
Okay.
But after all the presentations are made, whoever would like to come and speak to us, at the end of the day, we are going to go through almost clause by clause to see what amendment should be done.
Okay.
In other words,
that was kind of what I was
but
referring to.
the truth is that they did a broad overview,
right,
as Jamaicans for Justice have. But at the end of the day, when we come to deliberate, we have to see which section must be deleted, amended, or what must be added. And that we will do.
I'm a little confused, Chair. Are you saying that we've already gone through a clause-by-clause review of the existing act?
No.
So what we did was based on the presentation that the group had given us last week in terms of the issues set out in provisions.
So they did a broad overview and identify one or two sections that they know need some amendment.
Right, Chair, but what I'm asking for at this point, not at the end of the submissions, is a clause-by-clause review of the Act. Because with respect, while the ministry may have highlighted the issues they're having in relation to certain provisions and done a broad overview, I as legislator have a responsibility to consider a review of every single clause. You have a perspective, Jamaicans for Justice have a perspective, and other stakeholders may come with perspectives on clauses that you have not taken any issue with. So I am asking, Chair, if the committee could be taken through the Act on a clause-by-clause basis so we have a full understanding of the provisions and how they engage, and also some discussion as to other acts that may touch and concern the matters being dealt with in the Child Diversion Act. I think this is a committee not seeking to do a specific set of amendments. It's a committee seeking to do a review of the whole act. So I think that I am asking for that to be done before we continue any further submissions.
To be fair though, Senator Golden, there's no doubt it must be done, but it's usually done at the end.
Yes, when we're considering amendments, Chair, but I'm saying there's no context. There's no context at the moment other than the broad overview. And at the end, after people have come and persuaded me that this must be done, I'm saying I would like an unfiltered, unbiased review of the Act now so that we can put into context the various submissions we're making. I'm not talking about at the point where we're talking about which amendments we're going to apply. It's a different question I'm asking.
Okay.
No, if I might, member, I think that's why we've been given the Act to read it, and I believe that after the various things come in, then we can compile what it is.
You see, Senator, Senator Campbell Golden, may I just say, no, what I'm really saying is that there might be about 40 or 45, 44 sections. To be frank with you, it's only about less than half a dozen sections that really are being attended to, if I might put it, that need elaboration and adjustment. Yes.
Right?
Yes,
So
yes,
while Minister Dixon may only be concerned with 7 provisions, I may be concerned with 14. It's not for us to be persuaded by you. It is for us to take an independent view of the act and to consider your submissions and to make a decision. I'm not here to rubber stamp the ministry or Jamaicans for Justice.
No,
So
but
I'm asking for,
you'd
I
like
don't
an
know why the
elaboration.
request is difficult, but I'm asking for the team to take us through the act. That's what I'm asking for.
It's a most unusual request, I must put
It is
frank
not
with you.
unusual at all. I'm an academic. This is what you do. You inform yourself before you begin to be persuaded.
Yes. Anyway, you wanted to say something? We don't have a problem, you know. You know, the truth of the matter is that they can take you through the act, you understand? But it's just that, I mean, I don't have a difficulty because at the end of the day, we are going to go through the act. But if you want a preliminary going through the act, I don't have a difficulty. It's just that the normal thing is to do it at the end. But, so, Ms. Wigan, could you, at an appropriate time, maybe next Tuesday? Or
It is an extensive presentation, so we would need a lot of time. Just to say to you that from page, I forgot it, but it's in our formal submission, the section by section. Of course, though, it excluded 1 or 2 sections, so we will incorporate and be ready. Minister, next week, Tuesday would be short.
At a later date.
Yes.
But I think
Or
what
the
Senator,
session after that, maybe?
But,
yes.
Okay.
right, what
Yes.
she would like at least so that we know exactly what is in there.
Yes, that's correct.
Right.
So I'm saying that the submission itself at pages,
I'm sure you can do it in half an hour, okay?
no.
So,
We'll try, Minister. So from page 45 onwards, there's a section by section. It may be absent of 1 or 2 sections, so we will incorporate that and be prepared
right.
to
In
make
fact,
the
at the end
presentation.
of the appendix, at the end of their submission, went through clause by clause. All right?
Right.
No, we don't want to go on for much longer, okay? Because usually we try to complete by around this time.
Chair, can I just
Sure.
finish one other housekeeping matter? And I heard you on me speaking with psychologists to see if they come here. I'm uncomfortable with that process because there is a formal process where the Parliament writes. And I would like to know if such letters as usually go out have gone out, and in particular, whether the Children's Advocate, the CPFSA, and other bodies that are involved in the framework of this act have been contacted and are going to be making a submission. I'm not, I know we had a general call for submissions, but usually when we do that, we also target the stakeholders that have concern or have interest and who operate around the framework of the act that we're dealing with.
There's no doubt that I have been in touch with the Children's Advocate, and I'd asked for, in anticipation of a formal letter, for them to prepare a submission, okay? When I mentioned about the child psychologist, we will send a letter, but we're asking before we send a letter to the person you
Chair,
may
that's
know.
not how it happens. I don't have an informal conversation and then the Parliament writes. I'm
But
not an
we wouldn't
agent
know
in
who
that
to
way. The
write.
Parliament must write.
But we wouldn't know who to write.
But the parliament, that's the job of the parliament to figure that out. Who is the governing body of psychologists in Jamaica and have contact with them?
No, we are going to do so because we have some. And we are going
Good,
to-
well, fine. And can we agree that there are some critical people who need to come
No,
before
so
us?
what I mentioned that we are going to be inviting those persons who have been involved in the program. But you had mentioned that you know someone who might have some ideas, and
I
I
know
said,
psychologist chair.
right.
Yes.
So
But there is a
I'm saying-
psychological society that has made submissions to the Mr. Nash, you know this.
Yes.
There's a psychological society that have made submissions to the parliament before, and the parliamentary secretariat has the job of reaching out to those people.
All right, I don't have a difficulty asking Mr. Nash to just
It's
write.
not you asking, Chair, and the committee is asking.
No, the committee asking that you write the Psychology Association.
And the children's advocate.
No, the Children's Advocate has
and
been
the
involved.
CPFSA.
No, the CPFSA and the Ministry of Education, because the ministers and the committee have acknowledged that they will be submitting at an appropriate time, so that because Minister Dixon has been in touch, we didn't see a formal letter has not gone to Minister Dixon or to CPFSA. And if we have invited, and we usually invite all the people we know who are stakeholders. For instance, the Bar
police.
Association, we could write.
The police.
The police, no, the Ministry of National Security, we will be writing to invite the Ministry of National Security and or any agency within that body. So a letter will...
What I'm suggesting, Chair, is that not everybody has seen the ads that have gone out, because
Yes.
one or two of the stakeholders that you have mentioned, and I won't call any names, I have been in communication with
Sure.
this morning, and they say they have not heard of this committee. One said they saw it in the press, and
But
there
that
are
is- that is-
stakeholders who deal with this act.
Right.
So I'm asking the Parliament, the Parliamentary Secretariat, to do what we ordinarily do in committee, which is we suggest a list of people. Parliament may also suggest a list based on what they know the Act does, to write and inform them so that we know who is coming and who is not coming.
So
And we can have a proper review, an investigatory review of this Act. This is not tick the box for me.
Okay, so Senator Campbell-Golding, we are going to ask if you mentioned the Psychologists Association, right? Association of Psychologists, we'll write. I think we can write the Bar Association, which we had not done. We are going to be writing the Ministry of National Security. The Children's Advocate, we can just put in a formal further third conversation with us. The CPFSA and the Ministry of Education, they have agreed to come already. And if any member would like any particular body that we have not identified to be written to invite them, please let us know. Because like Hear the Children's Cry, they have already informed us that and sent us a message. We didn't invite Jamaicans for Justice, but they sent us that they would like to appear before the committee. From they heard the committee was, being set up. So we're happy that at least Jamaicans for Justice has come. We're hoping next week, Tuesday, to have Hear the Children Cry and maybe the Children's Advocate. And then at a later date, we'll look at CPFSA and the Ministry of Education. We would want the Association of Psychologists, Bar Association, the police, and all of those persons, so we can hear as many persons who would like to make representation before we deliberate and make some final decision. So apart from the members of the committee, Ms. Wigan, if you know of any other body that we should write, because they have been actively involved with the program.
Chair, yes, we have a stakeholder listing that I really ought to have submitted to Mr. Nash, and so as soon as we get back to office, we will send him the listing.
Please, at least we formally write them and they can indicate whether or not they want to come before us, okay? So, I think that we've dealt with everything.
If you're going to give her a list, then it's
That's okay. We'll get a list. You can also put in another advertisement on Sunday. We did one for Sunday.
There's going to be more advertisements.
There are going to be other advertisements coming out. Members, I would like to thank you for a very productive meeting. We did get a few good points made from Jamaicans for Justice. We had intimated that if there were any other questions you have for the members of the committee, we're going to meet next week, Tuesday again, so that if you have any other question, the committee members will be here from all of these meetings. And we're trying to see, next week, Tuesday at 2. And then we're trying to see if we can meet on the 11th. So we'll make a decision next week, Tuesday, to see if we can meet on the 11th again. Truth of the matter, colleagues, members, we would really like to hear and debate this and complete this thing by the end of March so we can present a report to Parliament sometime soon after, okay? And just maybe whatever suggestion in the amendment to the bill, we can do that as soon as possible. I hate when matters drag on for too long. So we are going to try and we would like to thank all the members who came. I thank Jamaicans for Justice, they had to go, and welcome and thank all the students, teachers, and parents from Mineral Heights. Welcome to the Parliament, and please, we are adjourning now, but you can meet some of the members as they go outside. So thanks for coming to the Parliament. Sorry.
Just wanted to note that the students want to come down and take a picture with the legislators. So if you could indulge them, please do so.
So we are going to invite all of you down, your lucky batch, come and sit in the green benches. Okay? So at this time we are going to have the meeting adjourned. Meeting adjourned until next Tuesday at 2 o'clock. So the students and the parents can come down and just take a picture sitting down in the Parliament.
The 2026 Reggae Gold Awards Ceremony, National Arena, Friday, February 27. Join the stars of reggae music on the red carpet as our grateful nation honors its musical ambassadors. Plus, performances by Richie Stevens, Etana, Chris Malachi, Lost and Kawa Reggae Band, straight out of China. Yes, a Chinese reggae band. To cap it all, the Reggae Messenger, Luciano live with the Reggae Gold Orchestra. And Ken Booth being inducted into the Jamaica Music Museum Hall of Fame. And PBCJ will be there to capture every moment, starting at 7:30 p.m. That's the 2026 Reggae Gold Awards Ceremony, National Arena, Friday, February 27. Another Reggae Month 2026 event.
It's Thursday, February 26th. In the headlines, National Road Safety Council raises concern over spike in child road deaths. Primary school students to learn financial literacy from the Bank of Jamaica's Common Sense program. In business news, Bank of Jamaica says Jamaica to recover from Hurricane Melissa in 2 years. Regionally, Antigua and Barbuda's Prime Minister Gaston Brown encouraged by the message delivered by U.S. Secretary of State. And in sports, Jamaica beat Turks and Caicos 7-0 in CONCACAF Under-20 qualifiers. This is the news on PBC Jamaica. I'm Simone Absalom Gale. The National Road Safety Council, NRSC, is concerned about a sharp increase in the number of children killed in motor vehicle crashes since the start of the year. Data from the Island Traffic Authority show that 7 children between ages 0 to 17 have died on the nation's roads since January 1. The fatalities include 3 children traveling in private motor cars, 2 on motorcycles, and 1 pedestrian, as well as 1 pedal cyclist. NRSC Vice Chairman Dr. Lucian Jones described the figures as deeply troubling, particularly against the backdrop of broader concerns about child safety. He noted that police reports cite excessive speeding and motorists failing to keep within their lanes as major contributing factors. The rise in child fatalities comes despite an overall 36% reduction in road deaths. As at February 25, 39 people have been killed in crashes, compared to 58 during the corresponding period last year. The Bank of Jamaica is set to launch a new online financial education game aimed at primary school students. The platform, called MoneyQuest, will roll out in April and target students in grades 4 to 6. The details in this report from Danita Rodney.
Speaking at the bank's quarterly monetary policy report press conference in downtown Kingston,